Hello?
Yes, sir.
Can
No
you hear me
audible,
now?
sir. Yes, sir. No audible, sir.
Hello? Can you hear me?
Yes, sir.
Thank God. Finally. Okay. Start.
Okay, sir.
Hare Krishna, I request you please start the session.
We have only got 16 participants. Okay, let us see how many join.
Pawan, can you hear me?
Yes, yes. Can you please switch on your camera?
Yes. Good evening to one and all. Welcome to our webinar on Collegium Reflexes, Analysis and Observation with Senior Advocate Aruneshwar Gupta, Supreme Court of India. I am V. Hare Krishna, the host of this webinar, and joining me is my co-host, Srishti Tomar. I would like to give you an introduction about our organization, the Venkateshwara Law Students Association. The Venkateshwara Law Students Association is a student-led organization that brings together law students to learn, grow, and engage with legal community through various events, activities, and webinars. The association aims to foster a sense of camaraderie, professionalism, and legal awareness among its members. The SVLSA also works towards providing legal aid to those in need. The association commits to providing its members with the knowledge, skills, and resources to succeed in law. These webinars cover a wide range of legal subjects and offer attendees the opportunity to learn from experts, ask questions, and network with other law students and professionals. The SVLSA has organized 15 webinars so far, 14 of which were national and one was international, featuring experienced speakers from legal fraternity, providing opportunities for the attendees to expand their knowledge, skills, and to engage with experts in the field. In addition, the SVLSA has a commitment to provide its members with the knowledge, skills, and resources necessary to succeed in law. Also to promote legal awareness among the public and providing legal aid to those in need. First of all, thank you, sir, for accepting our invitation to do the webinar. And I would like to ask Srishti Tomar to introduce our honorable guest of today's webinar. Srishti, over to you.
Thank you, Hare Krishna, sir. Good evening to one and all present here. Myself, Srishti Tomar, and today I'm highly honored and privileged that I have been given the opportunity to welcome our special guest, Mr. Aruneshwar Gupta, sir. Currently, Aruneshwar Gupta, sir, is practicing as a senior advocate in Supreme Court, arbitrator and peace mediator, promoter of conflict-free individual, legal revolution, and spiritual revolution. He is practicing in USA. He is practicing since 1976 in Supreme Court of India, and he represented some clients in USA and Singapore. He is an advocate on record and additional advocate general for the state of Rajasthan and Supreme Court of India for almost 14 years. He was the chief architect of the Sports Act enacted by the state of Rajasthan, Himachal Pradesh, Uttar Pradesh, which led to the change in cricket scene in India by successful introduction of IPL. He was Secretary of Supreme Court Bar Association and Vice President of Supreme Court, Advocate on Record Association. He has written various articles and made several presentations and addresses all over India and around the globe. He has published a translation of Srimad Bhagavad Gita, Understanding Supreme Court Better, 151 Facts You Need to Know, and he is co-authored of Supreme Court Arbitration Law. Now, I would like to hand over the mic to Mr. Aruneshwar Gupta, sir, to proceed the webinar.
Thank you, Hare Krishna, and Srishti and all the members of the Students Club Association. This is a very interesting topic on Collegium. When Hare Krishna told me he wants something to, understand among the students, I thought one of the most burning topics today is Collegium. And, people, at least the lawyers and the law students should have a very clear picture about what is going on. Because politics, both at the end of politicians and judiciary is one thing, but as a law graduate, as a legal, person who understands law, you must understand what is the real issue and what is the real problem. Now, when you talk of Collegium, when you talk of appointment, now Collegium basically relates to the issue of appointment of judges. Now, the issue of appointment of judges is at two places. One is at the judges in the High Court and the judges in the Supreme Court. The third, the lower judiciary, the entire judiciary, it is not a lower judiciary, but that is the judiciary, the trial court judges. That is all appointed by the High Courts. So that is covered by Article 235 of the Constitution. So the High Court in each state, along with the UPSC, they conduct examination, and at both level, at the additional district judges level and at the lower close level, the appointment is made, and there also a judge or chief justice, one of the appointees of the judges, is there as a part of the process of selection of judges. So when you come down to the appointment of High Court judges, or when you come down to appointment of Supreme Court judges, and particularly with reference to Supreme Court judges, we have, again, the basic document for each one of us as a lawyer is always the Constitution of India. And I always tell my juniors and associates who are with me or interns that if you want to see anything, first see the Constitution of India. So the power of Constitution, appointment of Constitution. So this is in two parts. You see, one is the power of appointment, and second is the procedure of appointment. So the power of appointment of judges, like also along with the lower judiciary is over the governor. The appointment of judges of High Court and Supreme Court finally is with the President of India. So when we talk of Article 124 or 219, where the appointment of High Court judges is there, the power lies in the 217, when it talks of High Court. The power is with the President of India. So there's no dispute, no discussion, no difficulty on the issue that the ultimate power to appoint a judge. So the warrant is issued, that is called a warrant. So the warrant is is signed by the President of India. Now, before I take the whole issue forward, let me give a very interesting event which happened in America. And that is one of the leading judgments on the writ of certiorari. That is Marbury versus Madison, which relates back to 4th of February, 1803. Now there the Federalist, the political, they were political, at that time it was Republics and Federalists. So the Republics were people, so these Federalists were who finally became Democrats. So in 1803, the Federalists lost the elections. And it was the Federalist, the warrants of the appointment of the judges in America, they were already printed, but they were not signed. So there the signature was undertaken by the Secretary of the State. So while the Secretary of the State was still signing them, the 12 o'clock time was over, and then the ministry was gone. So a writ was filed in Supreme Court of America for issuance of direction that all those judges whose warrant have been already prepared, the Supreme Court should issue a writ of certiorari, an amendment for appointment of those judges. So that was the first case of a writ of certiorari. And then the Justice John Marshall, who was the judge of Supreme Court of America, he dealt with it, and the whole issue of independence of judiciary and the writ of certiorari was dealt with. And finally, he said, no, the ultimate power is still again with the President of America. So we can't, issue finally we can't issue amendments to that extent. In India, so far as concerned, the basic issue is when we go on the power, so there's no issue on the power of appointment. The issue is the procedure of appointment. And that is where the whole controversy arises, that how the procedure will move on. Now, whether the procedure ultimately, the judiciary will have some say in the appointment of judges, the whole issue around, it revolves around the issue of independence of judiciary. The entire thing is about independence of judiciary. So the whether now under the constitution, it is very clear, like Supreme Court of India, that every court is bound by a order passed by the Supreme Court of India. So everybody, the entire, all the executive and then the legislature is ultimately bound by the judgments of the court. Nobody can say, because that will fail. That will lead to the failing of the constitutional machinery. So it says, this Article 141 says, law declared by Supreme Court is binding on courts. And 144 says, civil and judicial authority to act in aid of the Supreme Court. So ultimately, the order of the Supreme Court is a final order till it is set aside. So one of the major controversies which really came up in Supreme Court was finally the power between the parliament and the legislature, or the parliament and the judiciary, where it said that whether the constitution itself can be amended by the parliament. So that was 13 judges was constituted, because earlier in two judgments in 67 and 69, there were some controversies on the bank nationalization case, which is called as and then there's the Privy Purses case, where, in fact, the whole war started in the very first amendment when it came. So if you have some understanding, and let me tell you some understanding about the basis of the constitution is that after the 1942 Quit India movement, the two groups of people who came really supported the Indian independence were the landless labor and the industrial worker. So when 1947, when India got independence, one of the first issues of Jawaharlal Nehru, the Prime Minister, was how to put these landless labor, give them the lands, and how the laborers should get into the industry. So there was a dual. So 1948, they came out with an industrial policy. So under the industrial policy, the major industries were taken over by the government. And the Sealing Acts came in and the Zamindari abolition came in. So I'm telling you this. So once that came in and the first act was made, the Patna High Court struck it down. They say this is in violation of Article 19(1)(f) of the Constitution of India. And then Nehru, instead of coming to Supreme Court, they amended the Constitution. So that was the first constitutional amendment, where they said that, look, these land reforms can't be touched by Supreme Court. So that's a sort of this is basically the two powers, the wielding of powers, and the conflicts continue to take place. Because one is thinks that they are, and both of them, interestingly, the best part is that both of them are acting in the interest of the nation. But the whole perception is different as to what is the interest of the nation or what is the public good. So that is how the first amendment came in. So I'm telling you this background to understand that, look, the understanding of the parliament and the understanding of the judiciary is always on a slightly on a different angle on the procedure, on the whole perception. And both of them want to help the nation. It's not that they're not acting in the interest of the nation. Both judiciary as well as the parliament, both of them, because ultimately they are looking for public good. So after these two judgments, Privy Purses abolition and the bank nationalization, there came the Keshwanath Bharati's judgment, which is because I'm giving you these dates because then you can understand how the whole issue of Collegium has evolved over the years. So 24th March 1973 was the Keshwanath Bharati's judgment, in which the Keshwanath Bharati, the Supreme Court said that court cannot, the parliament cannot destroy or amend the constitution so as to destroy the basic structure of the constitution. So that is what they held. Now, immediately after the judgment, what happened was the first supersession. Though it was technically a second supersession, the first one held was way back in 50s, when one of the judges who was not well, he was not appointed the Chief Justice. So that was the first so-called supersession. So this was a major supersession where 3 judges were not who were in the line of becoming Chief Justice were not appointed, and A.N. Ray, who was the 4th judge, was appointed as the Chief Justice of India. Now, this was a major setback, a major understanding, or a major, thinking in the minds of the judges, who at that point of time constituted the court. It is not A, B, or C, or somebody on the A side or B side. It is as a whole judiciary as such thought that the independence of the judiciary is thwarted, is affected. And it is the parliament or the executive, they can just do anything what they want. Now, after this, the next event which happened was 25th of June to 75. To 21st of March 77, there was an emergency. Now, this emergency, as you must be knowing, and if you don't know, you must know about it, that Indira Gandhi lost, Indira Gandhi won, Indira Gandhi's election was set aside by the Allahabad High Court. And that Allahabad High Court, when the appeal in the Supreme Court came before Justice Krishnaiyer, who was a vacation judge, and he said, look, we'll not stay. She can continue to be a member of the parliament, but she will not be allowed to vote. And there was also a JP movement going on against the whole Indira Gandhi. So came the emergency. Now, during the period of emergency, this is very critical. During the period of emergency, when large number of, detainees were there were bail petitions, there were cases against, they filed protection cases for violation of Article 21, 19, 14. And during that period, Justice S.H. Seth from Gujarat High Court was transferred from Gujarat to Andhra Pradesh, and the date is 27th of May 76. Now, when this transfer took place, and this was, the facts were very clear that it took place without even the Chief Justice of India knowing about it. So all these, and so all the lawyers, they grouped up, and particularly the lawyers of Bombay High Court, because Bombay High Court, there's another very interesting issues in 1830s. Again, going back prior to the real High Court came into 1862, even before there was what they call the Supreme Court of Bombay. The Chief Justice of the Supreme Court of Bombay issued a summon to bring a 14-year-old boy to the court because of the case of between a matrimonial matter. The Governor General in Council at that point of time, he said, no, this boy will not be allowed to go to the court. Then the Chief Justice of Bombay High Court, he issued a direction to the Army Chief. And the Governor General said, look, if this man, Army Chief, tries to bring that boy, I'll send him in the ship and send him to England. So the whole issue of it, this conflict of independence of judiciary is a very serious issue, and particularly in the mind of Bombay people. Let me tell you. So Sirvai came in, and everybody came in, and they argued the matters of Sakal Chand. And Gujarat High Court finally struck down the transfer of Justice Seth. In Supreme Court, the matter came to Supreme Court. And Supreme Court on 19th of September 1977. Now, this is a date which is post-emergency. So, emergency was lifted on 21st of March 77. And 19th of September 77, Supreme Court upheld the Gujarat High Court judgment. And Justice Seth transfer was remained to be stood on. In fact, the government, the Solicitor General and Attorney General, they conceded to the issue that they did not pressing the matter, and his transfer stands cancelled. So this is what happened in the first matter, and there they very said clearly that the question of the real question was that originally under Article 124. So 124 says the President will appoint the judges of Supreme Court. But the language was after consultation with such of the judges of Supreme Court and the High Court of the state as the President of India may deem necessary. Now here the consultation, they made it very clear, the consultation is not just consultation. Consultation, you have to give the entire facts. It's like going to a doctor. So when you go out to a doctor for a consultation, you just don't say, sir, I have come and you see my blood pressure and give me medicine. There's a reciprocity, there is a whole, you give the history and you try to tell the doctor, look, so you are consulting a doctor. So that is what they said, that this consultation with the judges and the Chief Justice of India is not merely a paper, that you send a file and you expect them to give their signature. So it must be a proper consultation. So there should be an application of mind. So this was basically the first cornerstone of the Collegium, which came as far back as in 76. That is why I say the root of this issue goes 50 years back. It goes to Keshwanath Bharti. Then came then Indira Gandhi again came in. And that's very interesting. On 14th of January 80, she won election and she was back into power. And on 18th of March 81, the then law minister, now the issue was, when they say consultation of the, one of the major issues in Justice Seth's judgment was that at least the concurrence of the judge who has been transferred, his concurrence should be taken. Now, when Shiv Shankar, who was the law minister after Indira Gandhi came back in 80, he came in and he issued circulars. One circular was transferring of 3 judges of Chief Justice of Patna from Patna to Madras. The other was relating to the non-confirmation of additional judges of Delhi High Court. There are 3 judges. And third was that he said that all judges who are appointed now must give their concurrence for transfer to other high courts. Now, this was something amazing for the judiciary, that look, they said, look, this is too much. Because transfer of judges again is a condition of service. So government can do anything. So this was something which came up and this all was challenged in SP Gupta. And incidentally, I was there in SP Gupta's case as a junior to Mr. Mridul. And we really argued, because one of the major cases was that in SP Gupta, when the file of the Delhi High Court judges or the judges had gone to the Chief Justice, Y.V. Chandrachud was the Chief Justice. So the issue was whether those files should be presented to the bench. So the bench, SP Gupta's bench, was headed by Justice Bhagwati, P.N. Bhagwati, who was number 2 judge, because Chief Justice himself was a party. So he could not have presided over the bench. So Justice Bhagwati, one of the major issue was that whether it should be done. And interestingly, I told my senior to raise the issue of privileged communication. Though I knew that whole issue of there's no privileged communication service law. So that is exactly what I told my senior. And I said, look, at least a 7 judges bench will hold that there's no privileged communication in service law. So right now, all these issues where the ACRs are given in seal covers and all, because the law at that time and law right now also is very clear that the judges can't look into any document which is not shown to the other party. Ultimately, the judiciary has to be transparent. It has to be open. So when we raise that question, but incidentally in our favor, Justice Fazal Ali, he gave a dissenting opinion in our favor, and 6-1, they upheld that there can be no privileged communication in a service matter. But coming to the SP Gupta, they said, look, let us be very clear about it, that you can't issue circulars like this. This is not done. So the whole independence of judiciary is under challenge. So 81, again, this SP Gupta judgment came on 28th of December 81, finally. And even then, they made it very clear that the consultation of the Chief Justice should be meaningful and effective. It should not be off the cuff, it has to be very, and the Chief Justice has to consult it. Now, the whole issue continued from 81 onwards till 1990. Now, 1993, then there was a writ petition filed with respect to the appointment of judges, because the large number of vacancies are lying. So the Supreme Court Advocate on Record Association, at that time, because one of the major issue was that large number of advocate on records and advocates who wanted to become who want to become judges, and were quite a good group of lawyers we have got. And ultimately, why should you keep these vacancies at all? In fact, in all courts all over the world, all the appointments are made even prior to the date of their retirement, because you all know that he's going to retire. So why can't we have and there were almost like 400 vacancy out of 900 at that point of time. So almost more than 40, 50, 45% of vacancies were there for appointment of judges. That is where what came was the procedure for appointment of judges. So they said that, look, this consultation is not enough by the Chief Justice, though Chief Justice is the head of the judiciary. So whenever, and that was in SP Gupta. So they said whenever he is representing the judiciary, he is representing all the judges. But in SP Gupta, but in the Skora judgment, which is the Supreme Court Advocate on Record, they came up very strongly and said, no, the Chief Justice is not enough. For the appointment of judges of Supreme Court, it should be 5 judges, the 5 senior most judges. And for an appointment of a judge of a High Court, it should be 3 judges of High Court first, and then the 3 senior most judges of the Supreme Court, along with any other judge of that High Court in Supreme Court. So ultimately, the primacy of the Chief Justice is not disturbed. The primacy of the President is not disturbed. Ultimately, it is the warrant of the President. But the issue came that once the judges, they recommend the name. So this is the Collegium. This is what they call as the Collegium. The Collegium is only to do with the procedure. The power still is the President of India. So instead of saying that it will be consultation with such of the judges, they said, look, we'll have the so that the procedure of consultation was defined by them. They say, when you talk about consultation, it is the 5 senior most judges of Supreme Court. So they will now recommend the name of the judges, and then the government, there's a whole memorandum of procedure. If you go to the website of the Government of India website, you'll find a whole memorandum of procedure for appointment of Supreme Court judges and High Court judges. And that memorandum of procedure has been determined by both the government and the Chief Justice, by the judges. So that has already been defined. Now, there are certain vagueness in that procedure, which should be corrected according to me. So this is where the Skora judgment said, look, this is the way a collegium is there. And when they give the name, those judges should be appointed. Now, normally what happened is that sometimes, the understanding of the government is that the certain names are have to be reconsidered. So they send it back to the Collegium, and in the process, the judges continue to retire, because High Court judges, if they retire at 62, they normally don't come to Supreme Court. There are exceptions. There are judges who have been appointed even after retirement to Supreme Court, and not one, there are at least 6 of them. And there are at least 5 judges who have been appointed on the date of their retirement from High Court. So this whole process goes on. So this is the Collegium system. Then in 1998, there was a reference by the President of India, which is called the Special Courts Reference, where in 1998, where the Chief Justice of India, because there was some mix-up in the Collegium, so the names were sent by the Chief Justice. So the issue was that whether the Chief Justice can send the name, even if the full Collegium has not considered or cleared the names. So that was the reference which was made. And there the Collegium system was again established by the judges. So it is not just one set of judges. It is 93, there was another set of judges, 98, there was another set of judges. And then finally came the 99th Constitutional Amendment. The 99th Constitutional Amendment came in on 13th of April 2015, where instead of after consultation with such of the judges of Supreme Court, of the High Court, of the state that the President of India may deem necessary, they substituted it by saying that on the recommendation of a National Judicial Appointments Commission, referred to in 124. So there was a National Judicial Appointment Commission. Now, the only problem with the National Judicial Appointment Commission was, and that is what was unanswerable by the government, was that in 124 AD, they put up 2 eminent persons to be nominated in the committee. Now, these 2 eminent persons again is a very, very, open, instead of which if they would have said, look, like the Attorney General of India will be the member of the Collegium, or the Law Minister will be there. So Union of India in charge of the Law Minister was already ex officio member is number 3. So the Chief Justice of India ex officio 1, 2 senior most judges ex officio 2. So there were 3 people, the Law Minister, and they would have put the Attorney General and the Solicitor General. So that is what marked. If that was the Constitution, I don't think it would have been struck down at all. Well, ultimately, you have to balance it, but you can't bring a third person and an extra, extra judicial power into the Collegium. So that is where the whole, again, that is where they held that the independence of judiciary is being affected, and they struck down. So that in the Scora judgment, the second Scora judgment, which challenged the validity of the 99th Amendment, on 16/10/2015, the Collegium's, the 99th Amendment was struck down. And since then, that is the law of the country. Now, you must understand that. It is not an issue that the government, now the government of India has already come out with another, there's a private bill which has which has been there in the Rajya Sabha. So if Rajya Sabha and Lok Sabha pass those bill, and if the validity is upheld by the Supreme Court, that will become the law of the land. So today, this system which is in vogue is the law of the land. So even the Supreme Court judges can't do anything, because they can't say that we will go against the judgments of the Supreme Court, because that is binding on them, even on the administrative side. So till the law is amended and till a new system is brought into place, the system as it is existing will continue. Anybody may criticize, anybody may say anything about it, but to bring up a new system, you will have to create a new system. So this is the overall analysis, overall picture, and overall understanding of the Collegium. Now, if anybody has any question, you can ask it. The house is open.
Thank you, sir, for giving us an elaborate understanding of the Collegium system. I would like to request the attendees, if you have any doubts, you can unmute yourself and ask questions to our guest.
Or they can also put the question in the chat. That will be a better idea. If they put it on the chat, then maybe you can answer the question one by one.
Yes, sir, that's also better.
Because then you can take it by one. Otherwise, if they start all opening up their microphones and start asking questions, we'll be in a con.
Sure.
But if any of your panelists have any question, maybe I can answer them straight, because nobody is giving any question.
Sir, I have a few questions. What do you think is the better way to form better than the present system to appoint the judges?
You see, according to me, the ideal system is, because one of the major roles that has to be played is also by the bar associations. Now, everywhere there is a bar association, in all the high courts and all the Supreme Court. Now, in fact, these bar associations, before, at least 6 months before the vacancy arises, I am saying 6 months, and it is not rocket science. They must give at least 2 people name or double the number of vacancy, because every judge is, all the judges don't retire on a single day. So they can give the names of 2 judges, 2 lawyers, whom they consider, they can have a whole election for that. And give the name of 2 lawyers whom they think are best suited to them, because ultimately they have to, deal with the judges. And give the name, or give not 5, give 1, give 2, give 3. And those names should go to the government. And the government after that can, from 3, it can make it 2. Those numbers can be sent to the Collegium. Or those numbers can go to the Collegium, and the Collegium can make out 2 out of those 2 and then send it to the government that you appointed 1 out of them. This whole insistence of appointing of just 1 is bad. Like today, there are almost like 400 vacancies. If every high court, in Allahabad High Court, there are about 96 judges, the total strength is 160. So there are 64 vacancies. So they can appoint all the judges by giving the names of it. But somebody will have to work. You see, somebody will have to initiate the process. Our difficulty is that we as members of the bar, we continue to make, shout, and it's a good issue to talk in the canteen. Or you can talk on the platforms. But somebody has to work on it. And today, you see, the real issue is, and there's nothing wrong with it. Every lawyer who is a professional lawyer, and particularly those who are coming from the 5 years courses. Everybody. I'm not talking of NLU because everybody, according to me, is a good lawyer. So anybody who wants to, either he wants to become a, senior advocate, or he wants to become a partner of a law firm, or first preference is always a judge. And like Justice Dhananjay Chandrachud, Chief Justice, said on the last occasion, that judges, they don't become judges only because of, power or money. They want to become judges because they want to, provide justice to the people. So it is that, some people are passionate about truth and justice, and they think that, look, we can do good service to the nation. So you can pick up those lawyers. People are not blind. And those people can be picked up. Their name should be given. It can be given to the Collegium. Collegium out of say 2 people, or if there are 4, so they can pick up 8 of them, send it to the government, and out of the 8, they pick up the best. The government can, appoint the judges. But this should happen much in advance. Every judge, the problem is that if the lawyer whose consent is taken to become a judge and he's not appointed a judge, 3 things happen. One is he loses his practice, at least for that period, because he can't take new cases. He's going to become a judge, and cases don't finish in 15 days or a month time. Secondly, he feels very uncomfortable. In the bar says, your name was taken, nothing happened. So he becomes openly becomes a case of a joke, which is not good. And thirdly, he continues to spend his time in finding out by mera appointment ka kya hua. So this is not go. Once you take the consent of a lawyer to become a judge, he must be appointed. Either you don't take the consent, or appointing of the judge, or appointing them, or make him a senior advocate. You see, nobody in this world is without bread and butter. And everybody has got to, slotted for a particular scene. So if you are slotted for becoming a judge, become a judge. But the system should not, kill him. That's it. Now we have got a question here by Yashwant Kumar. If Collegium recommends some advocates as judges of the High Court, and if any district judge is on promotion for appointment as a judge of High Court, which will be preferred? You see, the line is very clear. The 70% of the vacancies are for the lawyers, and 30% vacancies are for the district judges. So everybody knows that these vacancies, how many vacancies are there for lawyers, and how many vacancies are there for a district judge. So there is no conflict between the appointment of a district judge or a appointment of a lawyer. The post, they have their independent, stream and percentages. And every appointment, it is very clear that who is to be appointed. So this number of district judges are to be appointed, and this number of members of bar have to be appointed. Anything else?
So Arun Chola has a doubt actually. Arun Chola, you can unmute yourself and.
Yeah, good evening, sir.
Yeah, Arun.
Yes, sir. As before SP Gupta cases, there is no transparency and it is secrecy. And after that, National Judges Appointment Commission, actually the 2015, the constitutional body, the cancelled by the High Court order by the Supreme Court. Till the collegium systems, there is no any transparency. Still, it continues secrecy. Then what's the solution, sir?
Now, what do you mean by transparency?
Yeah, it's, before the SP Gupta cases, actually the first they write that there is no any transparency for a transferor judges case. Judges transferor, there is no any secrecy. Then it's discussed with the
do you know a single case? Do you know a single case in which the judges was appointed after consultation with the public? Now, let me tell you a very similar example. My father was appointed as a judge in 1973. 73.
Okay.
And he was Chief Justice of Rajasthan and he was till 86. Nobody knew that he was going to be appointed as a judge in 73. You see, what the whole idea of this word transparency is very confusing. If I don't know, the things are not transparent. That's not an argument. Transparency for whom? Transparency for those who are going to appoint the people. There is transparency. All there, you see, there is a clearance from IP. There is a clearance for CBI. Everybody gives a judge. There's a medical test. So everybody who is in the process of appointment knows that he is going to be appointed. Now you can't put the name in the newspaper and say, look, here is a person who is going to be appointed. Vote for him. This is not an election. You're talking of the appointment of a judge. So who are the people before whom you want it to be transferred? You see, there are three types of debates that can be held. One is a debate in public, which you can hold everywhere, like we are holding a debate right now. Now, if you tell me who wants to become, I can't tell you who wants to become judge. The second debates are in parliament. Now, do you want the parliament to debate on the appointment of judges? And the third is debates amongst the people who are related to the appointment. It's like a cricket team. Think about cricket team. Now, the present cricket captain will continue as a cricket captain and who will be playing as a wicketkeeper, who is the people so there's a team for selection. So who selects the cricketers? The cricketers. You see, people who are part of that system only know who is the person who is best suited for that. You see, there are only two ways of appointment. Either you have an open competitive exam, or there has to be a system by which, now the real issue is that there must be data on lawyers and there must be data on high court judges. So there must be data which should be known, and amongst those data, you pick up the best of them. So now that is called, with the tools of artificial intelligence and, things as they're moving up, we'll have data of all the judges, like senior advocate. Now, recently in the Indira Jaising case, the Supreme Court has very clearly said that lawyers who have, how many propositions of law you have done, how many cases you have argued, how much pro bono work you have done. Now, all these conditions will be the reasons for making you a senior advocate. Similarly, I think soon the Supreme Court will also come up that the same conditions with more amendments. Like how many, like you want to become an high court judge. So how many national conferences you have attended, how many international conferences you have attended, and then how many papers you have presented, how many articles you have written. Ultimately, what are you expecting from a judge? That he should read, he should be well read, he should be courteous, he should be, he should be able to pick up the law and give justice.
Yeah, fine, sir.
All the parameters. So you have to adjudge all these people on who we are going to appoint on these parameters. And that is what is being done. It's not like that is not being done.
Yes, sir, I agree with. Before, actually, I got confused. Actually, if there is what kind of measure to evaluate the judges. So you told, you explained, elaborated, fine. I understood. Thank you so much.
Thank you. Because it is very easy to criticize everything. Everything can be criticized in this world.
Yes.
But when you are working within the system, and since I'm a third generation lawyer, my grandfather was the first registrar of Rajasthan High Court in 1950. My father was a lawyer in 1950 and he became a judge in 73 and he continued till 86. And I came down to now people talk of judge's son. I didn't become a judge. And it is not that I didn't want to become, but again, it was, if it didn't happen, it didn't happen.
Yeah.
So maybe I'm not suited for that. It's not the problem with the people are that everybody wants to become a judge.
Yes,
and there are limited positions. Everybody wants to become a Chief Justice of India.
Yes.
One of the major difficulties between the judges of Supreme Court itself is that, look, I could not become, though I was senior to him. He says, I was senior to him. Now that is bickering. That doesn't help at all. Ultimately, we have to work for the national development. We have to develop. In America, if you see, if people quote America, the Chief Justice of America is never a judge. He may not be judge of the Supreme Court at all. He's picked up from, they are got 9 districts. So every time any judge from any district retires, another person who is picked up from is from that district.
Yeah.
So, it's not that, it's not so simple. And these are not traditions which are, built up. That is what I'm trying to say. That Collegium system has roots 50 years. It's not today that the whole thing has come up and you want to throw it out.
Yes, sir. Yeah, I understood. Could you please elaborate? Actually, the 2015, the central government created one constitutional body, the National Judges Appointment Commission. Then the Supreme Court.
You look at 124 AD. Who are the 2 eminent persons?
Okay.
Who are so they will pick up 2 people to anybody from the head.
Okay.
You see, where do you get these 2 eminent persons who are more eminent than the High Court judges and Supreme Court judges?
Supreme Court judges.
So you can't get them. So you have to, why, if they would have put Attorney General,
Yeah.
why didn't they put the Attorney General?
Okay.
You see, today Attorney General is a person like Mr. Venugopal, if you take Venkat Ramani now, Soli Sarabji, you take K. Parashran. Now, these are people of the highest stature.
Yeah.
So why can't they be included in the Collegium? You see, so the whole issue was whether the institution, whether the structure of the National Judicial Academy, National Judicial Appointment Commission, that was under challenge. They say you can't have rank outsiders because then they will start putting up their pressures.
Okay.
Where do you want them?
Yeah, fine, sir. Sounds good.
And my thinking is very clear. And there was an article by one of the judges, retired. He said if they would have withdrawn 124 AD, the whole act would have gone through. But the game is that those who are shouting, they also don't want something to happen. And my understanding of, because I know something about this 2015 Act, they wanted to shout shout against the judiciary to say that we need a commission, but they also never wanted the commission to come in. That's the problem.
Yeah, fine, sir. Thank you so much for your time. And that sounds great. And thank you so much for explanation.
Okay, anybody else, or let us close the issue. It's already 5:50 now.
Thanks, Shruti, you have a doubt.
Shrishta, my question is, do you think the procedure is attaining its aim, or why it has been introduced free from compulsions? No, the point is, you can divide your question into 2 parts. One is the procedure. The second part is the data. You see the information. You're not holding examination on the judges. So how do you come out with the right person? So the only way to come out with the right person is to have a database right from the career. And this is very, very important for you who are lawyers now, because you must build up your database right from beginning as to how many cases you appeared with your seniors, how many cases you have argued yourself, what are the propositions of law that you have propounded, which the judges have taken up, how many conferences you have attended, how many papers you have presented, how many articles about law you have written, which have been published, how many blogs, if they are not published, you will put it on the blog. And then finally, how much time you have spent on pro bono. So you will have to find a way to determine. So it is not merely the procedure. Like you say, sir, what is the problem with the examination? That is not the examination the problem is there. The problem is with the nature of the question papers, with the nature of what you have been taught in the college. So the content, the problem is with the content, finding the right people to man the post. Like in army, if you see the army, you take sports, people now, a lot of people, you must be interested in cricket. You see how the selection is made. In fact, I was one person who we started when I drafted the sports act for Rajasthan. My idea was that the whole selection of players, and it is not only cricket, it is player. Whether you take badminton, you take tennis, you take running, you take swimming, and particularly women. There are a lot of problems. The coaches, there are no good coaches. And the selector, they all exploit the student. They want money. So, you have to create a structure by which the database is, even today, let me tell you, in sports, there is no database to find out who is a good player. Only because cricket is keeping a lot of statistics, you are able to find out, okay, this is a good player, this is a good player, this is a good player, this is a good player. No other sports. There is no database right from class 4 when the boy starts playing. You see, normally young sportsmen come at the age of 9 or 10. So they must have a database on all the sports person from age of 10. Like lawyers, they must have a database from the first date they enter the college, bar, they become a member of the bar associations. So now it is possible. You see, till now it was very difficult to keep this better database. But now I think so you have a very strong competition. Let me tell you very clearly. You'll have very tough competition because the best more best people will be coming in there. Okay. Anything else?
Sir, I want to ask, what is your personal opinion regarding the statement given by Kiran Rijiju that Collegium system is opaque?
But what do you mean? I don't understand this opaque and like Arul said, not transparent. According to me, it is absolutely transparent. Among the people who is doing it. Now, the judge will not tell me that we are appointing him as judge. So, for me, it becomes opaque. That's not the way it works. You see, that is not opaque for whom? Transparent for whom? The law minister knows it. All the people who are there who knows it. The law ministry. Because there's a file. You see, it's not that it is not without a file. The moment the name of any people is recommended, his whole file is there. And in fact, last time if you see the minutes of the Collegium, Justice UU Lalit, they got the list of all the judgments by that judge to check out whether the quality of judgment was good. And it's a lot of work. Today Supreme Court of India is dealing with 60,000 cases a year. It's not a joke. Sitting there and doing all this. You see, it is very easy to sit here and criticize. And this is, appointment of judge is one of the very important part, but that is one part. They have so much of work to do. It's going on and on and on. So putting a pressure on them doesn't make, according to me, doesn't make much of a sense. Right from our law minister, everyone wants to comment on the Collegium process, but do we actually know what is the process they follow? You go to the website, I told you already, there's memorandum procedure. Is it recorded for anyone to study? I'm sure that they won't be just sitting up with a cup of tea and start right. No. They see the entire record. Now it has become very, very difficult. They see the entire record of the lawyer. Like becoming a senior advocate. They see the entire working of the lawyers. And particularly with High Court judges to come to Supreme Court, they have all the judgments before them. Now, this will be what is called the multivariate regression, MVR. If you see that term, it's very interesting. So we will know that what is the approach of the lawyer, whether he is accused, he is pro-accused, or he is pro-conviction, or he is in favor of tenant, or he is in favor of landlord, or he is a neutral judge. You see, ultimately, we are looking for justice for all. And in every case, 50% people in whose favor the case is decided, they are happy, and 50% in whose favor the case goes wrong, they are unhappy. So it is not happy or unhappy, it is justice. So whether justice is being done in that case, so that will only come by more and more data. Now, you see, after this whole deep data analysis, that is called the deep data analysis. And when we apply some parameters on that, we'll get a lot of data from them. Sir, please enlighten about the law students also who are interested in litigation. Yeah, Tulip, this is very interesting question. You see, let me be very clear, right from your day when you even your college, start compiling your articles. You get your projects. Have a compilation and index of your project year by year by year by year. That look, this is what I did a year. This is what I did in this year. This is what I did in this year. So keep entire, if you want to become a judge or a senior advocate, keep entire data. And that all data, and then particularly pro bono. In fact, There's no way of determining the pro bono. So there is a formula that we are trying to work out now, that how to determine your pro bono hours. So maybe we can have a another seminar on how to calculate your pro bono hours. So pro bono means the work that you have done in which you are not being paid what you are entitled to be paid. So that is free. So suppose you do a case for your friend or a family member. So that is pro bono, because you can't charge. So the issue is not you can't charge, but you are not paid. So you have to get into a system where you calculate, and if you want to make a note, everybody can make a note. You see, the expectation normally is that every lawyer should work for at least 8 hours a day. And 8 hours doesn't mean the steady, 8 billing hours. And he must work at least 200 hours a month, 25 days in a month. And he must work at least for 11 months, totaling to 2,200 hours a year. Now, in this 2,200 hours a year, if you suppose your career starts when you join the bar and you say, look, I am entitled to 20,000 rupees a month, or 15,000 rupees a month, or 10,000, whatever you see your valuation, you take out your annual. So you multiply it by 12, multiply by 2 and divide by 1,000. So if you're paid, say, suppose 20,000 rupees a month, so your total value is 480 rupees per hour. So if you are paid at 480 rupees an hour, it is fine. If you're not paid, then the other part is all pro bono. So you can work out a formula that, look, I paid 20,000, but the output, my working is, I'm only getting, say, I'm entitled to 40,000, I'm only getting 20,000. So my 20,000 rupees is pro bono. Or my 500 hours in this year, I've been pro bono. But then you will have to keep an account on whatever you do as a professional. And our problem is that we don't keep our account, we don't keep our house in order, and we continue to criticize the system. Which is not fair. You must not criticize the system. You must see how do you fit it into the system. Okay. Anything else?
Okay, sir, I think that's it for the day. We hope this webinar will provide valuable insights and a better understanding of the Collegium system and its functioning. We encourage, on behalf of the entire team, I would like to express our heartfelt gratitude to our Senior Advocate Aruneshwar Gupta sir for sharing his expertise and insights on the Collegium system with us today. Your depth of knowledge and wealth of experience have truly enriched our understanding of this important topic. I would also like to extend our thanks to our co-host Sisti Tomar and Mahendra Reddy, and also our organization founder K. Pavan Kalyan for their efforts in organizing and moderating today's webinar. Finally, I would like to thank all attendees for joining us today. We hope you found this webinar to be informative and valuable. We look forward to hosting more events like this in the future. And I would like to say one thing, sir, before ending the webinar. Recently, SF Nariman, the senior advocate, said one thing, that Collegium system is better than the evil one, which is the NJSC. I hope you agree with that. I hope. Because
I'll not comment on anybody's, because for me, I only go by the law of the land. I am not a person to determine what is right and what is wrong. Because, and these politics, I call them, I don't want to use that word, but there are a large number of pseudo lawyers and pseudo politicians. So they continue to make their own statements depending on their own benefits that somebody will get. So you don't know the undercurrent. So I always say, whatever the law of the land is, if today the system is collegium, follow it. Today, if the system is that that there's an appointment committee will do it, follow that. You see, end of the day, it is not, nothing is good or bad. You see, because I am nobody to determine what is good and bad. I am a lawyer. My work is to be a lawyer. I want to help my clients to get the justice. So I want good judges to be there. And it is a duty of the judges and the parliament or the executive to appoint good judges. So this whole shout about power and all, and end of the day, we are all looking for the interest of the nation. So every judge is, if the judgment is not good, there's not a big problem. If the judges are not good, you go to appeal of the case. Point is, and then you try to find out the best people. How much? I don't know how many people Mr. Nariman have, how many juniors of Mr. Nariman have become judges. I know about of course, about his son, who became a judge of Supreme Court. In fact, Soli has produced more juniors who came to Supreme Court and who were senior advocate. So, it all depends. You can't comment on A, B, Mr. Nariman or Mr. Palkiwala or Mr. Sirvai or Mr. Soli Soravji or anybody. So it is, these are all personal opinions about people with so many things. I have got a very different opinion because I go by the law of the land. I am a lawyer, and as a lawyer, I am bound by whatever the law exists. And I may have reasons. See, if I've got a client and something says that these are all academic debates, in fact. Whether A system should be there or B system should be there. But I am one person who has a very strong feeling about the independence of judiciary. But independence of judiciary does not mean that you continue to go against what the government wants to do. Because ultimately, it is a national interest. Like, what is national interest? Is getting foreign direct investments, getting more money into the country through the right channels. Foreign direct doesn't mean that you get it through Mauritius. So, there are a lot of things. So these are very, anybody's statement like this is, I'm a serious question because I am not a public. You see, I am not one person who likes to be, coming into the public, and maybe Mr. Nariman has still more things left to say.
Thank you, sir. And as you said, at the end of the day, it's the law. And thank you very much, sir. And I thank Srishti Tomar and Pavan Kalyan and all other backward teams who had made this possible to have this webinar. And also, sir, if possible, we will do more webinars also.
You continue to do your webinar. Best wishes to you and best wishes to your organization. Continue to do it, but I think participants are not increased more than 21. So you'll have to, I have more participants coming up.
Well, this is a small organization, so we just started it. So we can give more.
Okay, whatever it is. Best of luck.
Different live streams. Not only in Zoom, sir, we're providing in YouTube and Facebook Live also, sir. So that's why participants are less in exact Zoom meet.
Okay.
Thank you so much, sir. Thank you so much.
Thank you.
If possible, anytime you come to Tirupati, please visit our university also, sir.
Tirupati, certainly I'll be coming someday or other.
Sir, thank you so much, sir.
We'll certainly see you, but maybe by the time you all passed out already.
No, sir. We are now.
We stay nearby only.
Okay, you stay there only. Okay, so let us see.
Thank you so much, sir. Thank you.
Okay. Thank you,
sir.
Thank you, Shrishti. Thank you, Hare Krishna. And thank you,